Hey, and welcome back. Why don't you use United States codes or the statute verbiage when you intend to invoke any supposition of law? Why do you actually use a General Act, Public Law, Public Act version? Simple. The codes, whether it's on a state or federal level, are not official. It does not demonstrate any form of authority for anyone to act upon. 3. There are two types of evidence. There's prima facie evidence and there's substantial evidence. The codes are prima facie, meaning the limit of its value is what you see on its face. It has no signature, no stamp, no seal that makes it self-authenticating, and it's not admissible. Substantial evidence, on the other hand, is admissible. Codes on a state or federal level are just for show. They're just compilation of what happened somewhere without certification. If anything is compiled and it's certified, it's self-authenticated. But codes are compiled but are not certified, so they are not authentic evidence of the laws. They're prima facie though, meaning you can read it and rely on it and say, okay, maybe that's what it says in the actual law that was passed. In other words, hearsay. And oftentimes it doesn't qualify for exceptions. Another issue with codes on a federal or state level is they omit the truth. They omit certain verbiages. There's certain things on a certain level when you start functioning whereby you will need certain things in certain parts of that law that's being codified, but the codified version will not show that part. Have you ever read USC codes or state codes and you see omitted? The law didn't omit it. The compilation omitted it on purpose, because somewhere along the line, while somebody's compiling it, oftentimes attorneys, they omitted it because those are the things that will free you. It says the Code of Law of the United States of America. Now this applies on a state level also for your respective state codified versions. Variously abbreviated to Codes of Law of the United States. United States Code, US Code, USC, or USC, is the official compilation and codification of the general and permanent federal statutes of the United States. What is codification? Codification in law is the process of collecting and restating the law, meaning it's not the original verbiage of the law. It is simply reiterating certain things. And in the process of that, there can be errors of a jurisdiction in certain areas, usually by subject, forming a legal code, codex, book of law. In common law, such as that of English law, codification is the process of converting and consolidating judge-made law into statute law. Process of codification. The official text of an act of Congress, meaning the official text, not the code, the official text, the law itself. The act of Congress. Congress is the legislative department of the government that makes the law. Is that of the enrolled bill, traditionally printed in parchment, like you will cast spells in your own door on parchment papers, presented to the president of his signature or disapproval, meaning it's going through the proper process of becoming law. Upon enactment of the law, the original bill is delivered to the Office of the Federal Registrar within the National Archives and Record Administration, NARA. After authorization from the OFR, copies are distributed as slip laws by the Government Publishing Office. The archivist assembles annual volume of the enacted laws and publishes them as the United States Statute at Large. This is the proper process, the Statute at Large, of putting together and arranging the enacted law that's passed by the Congress through the proper process of approval and disapproval. So what you should be looking for if you want to look at any type of body of laws that are put together in specific orders, the Statute at Large. By law, the text of the Statute at Large is legal evidence of the laws enacted by Congress. Slip laws are also competent evidence. Slip laws are like the public laws and whatnot, which is the original version. Slip law in the United States, a slip law is an individual act of Congress which is either a public law or a private law. They are part of the three-part model of publication of federal statute consisting of slip law, session law, and codification. The United States Code is the result of an effort to make finding relevant and effective statutes simpler by reorganizing them by subject matter and eliminating expired and amended sessions, even though those previous sessions. The Code is maintained by the Office of the Law Revision Council of the U.S. House of Representatives. The Law Revision Council determines, the LRC determines which statutes in the United States Statute at Large should be codified, meaning the law that's created, meaning it's initially compiled according to law. Then they determine, okay, this thing that's normally compiled in a normal way, we will determine which of them that we will pick and choose to codify. I mean, if you're reading codes on a state or federal level, you're reading about half of what's really intended to apply to whatever circumstance that you're dealing with. Then goes on to say, in which existing statutes are affected by amendments or repeals, but have simply expired by their own terms. The LRC updates the code accordingly. Because of this codification approach, a single name statute, like the Taft-Hartley Act or the Embargo Act, may or may not appear in a single place in the code. Then it goes down to say legal status. The authority for the material in the United States Code comes from its enactment through the legislative process and not from its presentation in the code. For example, the United States Code omitted 12 U.S.C. 92 for decades, apparently because it was thought to have been repealed. And well, our bad, we thought it was repealed, so we just omitted it. Oops. Probably something important there for you to know, but hey, well, you should have looked into it yourself. In its 1993 ruling in the U.S. National Bank of Oregon versus Independent Insurance Agents of America, the Supreme Court ruled that subsection 92 was still a valid law, meaning if you're using U.S. codes and you attempted to sue someone and there's a clause that has exception for that thing that you're relying upon, or that basically annuls whatever it is you're relying upon, or adds upon whatever it is you're relying upon to make it stronger, but the U.S. codes or the state code somehow omitted or put it to the side for whatever reason, whether they thought it was gone or it didn't exist, or because they purposely left it out, whatever it is, and you're trying to sue someone, or you're trying to say someone can't sue you, whether it's child support, mortgage, traffic tickets, whatever it is they're bringing against you. If you're in court, you're being sued. Whether you're acting as a defendant or you're acting as the claimant. If you're relying on the codes, they are letting you know that, look, there's been some case laws in the past whereby some people mitigated and litigated matters, and it turned out that part of what they were relying upon was incomplete. And the court eventually concluded that, yeah, you're dealing with incomplete laws here. And part of it is still valid, and you're missing it. It's like going into a battle with an armor that has cracks and chinks in it. Going with a battle or a sword fight with a blade that's cracked. By law, those titles of the United States codes that have not been enacted into positive law are prima facie evidence, meaning on its face. The limits of its value, it's on its face. Prima facie is a Latin expression meaning at first sight or based on first impression. The literal translation would be at first face or at first appearance. So whatever you see is the limits of its value, nothing more. It's not official, it has no seal on it, it's not certified, it's not admissible. It's just what's on its face. It's just what you're seeing. It doesn't prove that anyone is liable to it. It's just what someone just hands to you. If a dispute arises as to the accuracy or completeness of the codification of an unenacted title, the courts will turn to the language of the United States Statute at Large. They are letting you know, these courts that everybody hates so much, they're saying these guys are frauds. They're letting you know they only listen to the United States Statute at Large, which is the formal way that the actual laws themselves are organized rather than the codes. So now you bring in this code and that code, 18 USC 241, 242. You bring in all this law, you use 42 USC 1982, Civil Rights Act, all this, and they're not acting upon it. And at the end of the day, you're crying about, screaming and yelling, upset, expressing that they're fraud. That's their court. That's their laws. Of course, that's their laws, and you're using it. Who's the fool here? You are the fool, because you are not using the proper thing that they're liable to pay attention to. Everything else is just a supposition of what it's supposed to be, based on what someone else has put together and they're putting to you in front of you, not what the legislature themselves have enacted. And they even let you know that they will omit certain things. Are you a United States citizen? No, we know you're not. But if you plan to interface with entities, subsidiaries, enclaves of the United States, who will come at you, who will bring the battle to you, and you don't know the terrain that they function in, you don't know how their weapon functions, then that weapon that is formed against you will prosper. If you don't know the terrain and the weapon that your opponent is using against you, you can scream out at the back of your lungs, "No weapons formed against me shall prosper," aka you don't have jurisdiction over me. You don't have jurisdiction. If you don't know these basic differences, then that weapon that's formed against you will go beyond prosperity. It will kick your ass, take what is valuable away from you, and leave you in the trash. It will leave you angry. It will leave you upset. Someone just has to be honest with you. If you don't know these basic principles, there is no way you can properly invoke the lack of the specific types of jurisdictions. So the presumption here is not that you're learning this because you want to put yourself back in a jurisdiction, because that's the first thing people just yell over the place. No. You're knowing how they function so that you can go into battle properly. You don't want to go into the battle blind. But if you want to do it at your discretion. They're letting you know, independent of whether you use the USCs or the statute at large, which is the proper collection of the public law themselves that Congress had enacted. Regardless of whatever you use, the courts will turn to the language of the United States statute at large if a dispute arises to the accuracy or completeness. So tell me, whenever anything is brought against you, what do they use? They use the codes. They never use the statute at large. That is one of the ways that everything is being changed into a quasi jurisdiction. Ever wonder why all these courts are quasi? The mere fact that the only thing they adjudicate are the codes, not the statute at large. You bring that in. That is how you bring the court in. You hear people say the court is your paperwork. The court is your paperwork. You can run your mouth all day on a piece of paper. If you're not bringing the statute at large, the public act, the general law of your state into the equation, you're not holding court. You can send all the administrative process all you want. First notice, second notice, third notice. Do what you think is a notarial presentment all you want. If you're not bringing the actual law into the equation as substantial evidence, you're screwed. You're just jacking off. And they're just sitting in the corner looking at you like, yeah, here goes another weirdo. It goes on. In case of a conflict between the text of the statute at large, which is the proper collection of the law enacted by Congress, and the text of a provision of the United States Code, which is some other stuff that some other private corporations are copying and pasting and omitting as they wish. It's their private copyrighted interest. That has not been enacted as positive law, meaning USC codes are not positive laws. The text of the statute at large takes precedence, meaning it supersedes. In contrast, if Congress enacts a particular title or other components of the code into positive law, then only Congress can then look at the code and say, you know what, we'll make this a positive law if we want to, outside of what we've already decided. The enactment repeals all the previous act of Congress from which that title of the code derives, In their place, Congress gives the title of the code itself the force of law, which they don't. So the only thing that can validate U.S. codes as having the force of law is if Congress had enacted it, and they don't. The only thing they enact is the United States Statute at Large, not the United States Code. This process makes that title of the United States Code legal evidence. That is, if Congress enacts the United States Code, which they don't, of the law and the force. Where a title has been enacted into positive law, a court may neither permit nor require proof of the underlying original act of Congress. There are only very few United States codes that have been co-signed by the Congress outside of the actual enactment within their proceedings and the approval and disapproval votings of whether they should go into law or not. What is statutes at large? The real law? What do they look like? They will tell you. Public statute at large of the United States of America. It will tell you what year, from what year to what year, and then it will tell you the section at the top. It will tell you the chapter at the top. This is what, on the United States level, what actual law looks like. Hey, just a quick reminder, don't forget to check out the Patreon page. There you'll find documents that been used personally successfully and other deeper details on how to actually use these things beyond what they are, who's involved, and why. Only so much can be said on YouTube platform, and a lot more details and things people are seeking and they can't find, or things they seek and are not too sure about. And if you yourself have any specific questions or any specific topics that you want to hear about, learn about, then the Patreon page is the place. You can directly message me and let me know, and if I know about it, I'll be more than happy to share it with you. If I've done it before, I'll be even more than happy to share it with you. All right, take care.